Okay. We'll be live in about 30 seconds. The only weird thing is there's a 20-second delay.
Okay.
So
Which?
I can't sit here and check it though. I got to go back and check it in Chambers. Let's see. I think we're live. All right, so I will be ready to go.
Oh yeah. I'll ask you.
Absolutely. I did too first. But, you know.
Thank you.
What was wrong with it? Lame. At least it wasn't a strike drive.
I don't strike.
Especially like the small strikes. I mean, that's really, the sugar thing. I dressed up and everything. Put on hard clothes.
Yeah, just the zippers.
How many years have you been out with that?
Yeah, I just have everything is purple now, because we're else.
I was kind of excited too. Actually, personally.
The night raise, Saturday, I was like giants, who was wearing all this stuff.
I'm glad we did. You see that video that we posted about that?
Honestly, I don't really love that. With all the what is it? I thought it was a pie.
Yeah, getting written up. And that doesn't smell at all. This would make you.
No.
And the dog, this, okay, the video, it's like, oh my God, and the dog is bleeding. And then she cut it.
That's what I'm meant to get back there. So.
You can crawl under.
Yeah, cool. No. Kind of movement.
You wanna go now or you wanna go later?
Either way here.
No, you should be ready.
What was the?
Then you might be able to wait a little bit.
Good to know. I haven't set them up yet.
You're in charge of that.
I am for Zoom.
Okay.
But anybody now can use those.
Yeah.
Group chat things on Facebook.
Okay.
The video. Those are great. We did on those girls.
Okay.
Do a fire chief of I'm gonna do, we'll have to sit again and reading shares. I used to. Poor woman, she just been. How's she doing?
She was straight beside it, so it's like private.
She wasn't banged up or anything.
No, it's just, she's driving this, oh, I'm driving, and I thought parts. Because the truck ripped off the side of her mirror on the side and then straight to the car. And apparently there's more accidents. She must have got she must have left the right there. Because, comes down her insurance.
No.
But she was
Was law enforcement. It's a health case with them.
This is certainly scam saying, I think it's a picture from the eighties. What's our Vancouver trip?
I thought that was from the
It's from the boat
dinner,
ride.
right?
It's like, oh, here's a nice picture of you, Joe. I can put it there. It's like, oh, yeah, I didn't have a It is a comment on my hairstyle. What's that about? Yeah.
I think you just thought you looked cute. How you
When pulling the wrinkles back.
And the Vaseline over the lens.
That helps. It's that Vancouver lighting.
You can have, let's say, oppose you, you know, how to do all that. We had drama down at top of the board. Emiliano, he lost his first key.
Oh, did they remember what other?
Oh, yeah. But they showed me, he was, you know, I want a video call, he moved the clear right. So that was like 2 days later, I said, all right, that's coming out. And he was like, he was really working.
He did a great good job. Nobody tried to get there out of me. That was really.
He got 50 pesos.
50 pesos.
That's only like 2.5.
Hey, that's pretty good though.
Still not bad.
It's better than quarters. Elizabeth, the way you would get a loose tooth and Elizabeth would walk out in another room with tissue and he'd pull a. Where's the teeth? He'd learn. There was a couple times they put them under the pillows and didn't tell us. Carried it out. It's like, the jig was up.
Actually, when I was down there 2 years ago, the point that I wanted, mom off was it was this all dentist kit. It was like a plastic kit that you could open up, and then it had all the teeth in there, and I had a little where you could make fillings out of
Was it
plastic.
big Play-Doh?
Yeah.
Oh, yeah. I was done. Yeah.
I should have asked if he could make a filling out of it.
Yeah. If you look at the little teeth out of the white.
Gross.
Had a recipe for one before, so sounds better.
Tried it, baked it.
Baked it, yeah. me a little phase of traps that I saw in Target. I thought, okay, I love her. And it told me like third grade crafts, it's like one of these made up like a toilet paper roll turns into an angel.
Oh, yeah.
So every morning Liz is getting up, getting my Halloween kit picture about 30 seconds before it gets started. Yeah, a lot of regression happening.
I'm having my which one,
So,
I've chicken and rice.
oh,
We put them on top of the rice. That's
oh, that's there.
and I'm like, so that German
Oh, German bread.
and my ninja bread.
Oh, okay.
Where did it?
Yeah.
Found that out, you know, she never used it. I'll take it. I still got that in my future for Mexico, I'll never be around with those. Christmas Eve, I'm gonna do, onions. Just white onions, but then you make brown sugar and cider vinegar. Glaze like, after the, all. This looks. I saw Jenny Oliver make it on the show. He's got that one that's all vegetarian. Yeah. For Christmas Eve, does anyone actually eat it?
Now they like that when they were younger.
Just the hot mess.
Yeah, we just eat that, yeah, the milk with broth.
Weird and yeah.
It's been very busy. Monday.
Yeah. See, we had,
What's been nice and good and good, that, for one thing.
I think up till then,
People are texting.
no, I'm not sure.
Are they just positives or are they going to hospital?
No, there's. And we've got that 40. All right. You know, I don't know. It wasn't enough for all. I really want to get serious.
Outside of this case, we come back, and this thing, and we come back to that reaction.
Yeah.
We're trying to, hear
Much better.
You already said, you want.
Right.
I told him he can.
You looking for any?
Yeah, that one, yeah.
Word out.
I think that one, Jennifer, and we still have which one. Registered in the.
Forward.
Yeah. And then through the. Like the family then, if we wanted to propose it, I said, go over there and that.
Are they still there?
Oh, yeah, they're still there, just like they were the sort of. But you always kid them for that.
I forgot about that. Maybe I don't know this up.
It's so difficult plumbing job. Hey, totally bring this everybody. Joe. Oh, what's your job?
That's my business.
Yeah, you know, anyway, just leave it like this.
Yeah. We really, really. There's no way to repurpose these treads. I could replace the treads. I could probably do that. I think we could do that.
Well, I'm not putting the red.
Right. Plus, I think we have enough baseball.
Party rock. I think
Wonderful.
yes, it will. The daughter runs track. And they're all in stock, you know. You're where they're.
That's a good ball game. Because it's made with, it's not, you know, so you
I don't think they go off that side of our house.
can.
The other side. Because that's what we do.
No, I'm just wanting a shared structure.
Yeah. Notice it. I noticed it. Wow.
No, okay, I was just gonna make sure I had shield depending on. Ready? shield that you can wear? Or do you need one?
I have one back in my office.
Would you mind wearing it for me?
Sure.
Thank
Yep.
you. See if I can get that and put it on too.
Of course, we'll go to-
Okay, thank you.
I'm.
And then you can put the certificate. It's got 12 on it, so you can take that out.
I'm ready.
Are you guys ready?
Yep.
Okay. Good. I'm gonna come through there, so, oh, okay, thank you. Please rise. The Iowa District Court for Monona County is now in session. The Honorable Zachary Hindman presiding.
Thank you. Please be seated. All right, we are here today in the matter of the state of Iowa versus Elliot James Stowe, Monona County case number FECR 017250. This is the time and place set for a sentencing hearing in this matter, as well as a hearing on post-trial motions. The state of Iowa is present today by Monona County Attorney Ian McConaughey, and the defendant is present in person, as is his attorney, Ms. Jennifer Solberg. Just so the record is clear, we are pursuant to an order I entered in this court yesterday, live streaming this hearing. It's by way of YouTube and my YouTube channel. The link to that channel is present in an order filed yesterday. Like I said, in that order, the reason we're doing that is because we don't have any overflow capacity here at the Monona County Courthouse. And so anyone who is not able to sit in the courtroom today because of social distancing measures will be allowed to live stream in lieu of being personally present. Before we begin with the defendant's post-trial motion, anything preliminary we need to take up from the state's perspective, Mr. McConaughey?
No, Your Honor.
Anything preliminary on behalf of the defendant, Ms. Silver?
No, Your Honor.
Very well. I have reviewed the defendant's motion in arrest of judgment and motion for new trial. Anything further on that motion, Ms. Silver?
No, Your Honor.
Mr. McConaughey, I have reviewed the state's resistance to the defendant's post-trial motions. Anything to add to that motion?
No, Your Honor.
Very well. Like I said, I have reviewed the defendant's motion in arrest of judgment and motion for new trial. I also reviewed the state's resistance, and I reviewed the cases cited in both of those filings and considered those cases and the parties' respective arguments together with my written ruling that I filed in this case back on November 13th. Having done all of that, the court stands by and reaffirms all of its prior rulings, all of which are the subject of the defendant's motion in arrest of judgment. The court finds in relation to the defendant's reassertion of his motion for judgment of acquittal that the court's verdict is supported by substantial evidence. The court also finds that its verdict of guilty in this case is not contrary to the weight of the evidence as contemplated in State versus Ellis. And both of those findings with respect to substantial evidence and with respect to the weight of the evidence are based on the findings, analysis, and conclusions set forth in the court's November 13th written ruling. I also note for the record that I am aware that two different standards apply to those two different issues, and I've applied those standards as required by Iowa law. I also decline at this time, and for all those same reasons, to amend my findings of fact and conclusions of law, or to make any new findings and conclusions beyond what is contained in the November 13th order. With all of that said, then, are the parties prepared to proceed with sentencing Mr. McConaughey?
Yes, Your Honor.
Ms. Silver?
Yes, Your Honor.
All right, then we will go ahead and proceed. Any witnesses or evidence on the issue of sentencing Mr. McConaughey?
No, Your Honor.
Any witnesses or evidence on the issue of sentencing Ms. Silver?
No, Your Honor.
Any argument with respect to sentencing Mr. McConaughey?
Your Honor, the sentence imposed in this case is statutorily required. I don't have anything additional to add in terms of what sentence should be imposed. However, I would ask the court to take note of the fact that I did file a statement of pecuniary damages and ask that that be entered in the court's judgment.
Very well, thank you, Mr. McConaughey. Ms. Solberg, anything by way of sentencing argument today?
No, Your Honor.
Very well. Mr. Stowe, you have what is called a right of allocution. What that means is that before the court pronounces sentence, you have the right to address the court yourself. You are not required to speak if you do not want to, but if you have anything to say, now is the time. Do you have anything you would like to say today? Very well. Pursuant to Iowa Code Section 901.4b, the court is required to address on the record any victim of Mr. Stowe's offense who is present at sentencing. A victim under Iowa law is a person who has suffered physical, emotional, or financial harm as the result of a public offense other than a simple misdemeanor committed in the state of Iowa, and that includes the immediate family members of a victim who died as a result of such an offense. Any such victim who is present at this sentencing hearing may be heard either by a written victim impact statement or otherwise by addressing the court directly. I don't see any written victim impact statements. Is that correct, Mr. McConaughey?
That is correct, Your Honor.
As far as you're concerned, that's correct, Ms. Solberg?
Yes, Your Honor.
Very well. Is there anyone here who believes himself or herself to be a victim of the offense at issue in this case who would like to address the court before the court imposes sentence? Hearing none, we will proceed. Mr. McConaughey, do you know of any legal cause why judgment and sentence should not be pronounced at this time?
No, Your Honor.
Ms. Solberg, any legal cause why judgment and sentence should not be pronounced at this time?
No, Your Honor.
Very well. Then it is the judgment of the court that the defendant stands convicted and is guilty of the crime of murder in the first degree, a Class A felony in violation of Iowa Code Section 707.1 and 707.2 subsection 1, as set forth in the sole count of the trial information filed in this case. The court has received all of the pertinent information contained in the court file and has reviewed all of that, has considered the statements of counsel, if any, and all other pertinent information relevant to sentencing. The court has considered all of the sentencing options available to it under the applicable law, which effectively are none, at least with respect to the term of incarceration. And thus, like I said, the court has one and only one option with respect to how to proceed today. The court therefore orders that the defendant shall be confined to the Iowa Department of Corrections for the rest of his life without the possibility of parole on a single count in the trial information in this case. Minimus is immediate. In fashioning that sentence, the court has considered all the relevant sentencing factors, including the rehabilitation needs and rehabilitation propensity of the defendant, the need to protect the community from further offenses by this defendant, the nature of the offense, the circumstances of the offense, the age of the defendant, and the fact that the sentence which I just imposed is mandatory under the applicable statute. The court further orders that the defendant is required to make restitution in the amount of $150,000 to the heirs of Cheryl Stowe if she died intestate, or to Cheryl Stowe's estate if she died testate. That's pursuant to Iowa Code Section 910.3b. Ms. Solberg, I see that you have filed a request for determination of the defendant's reasonable ability to pay Category B restitution. Is that correct?
That is correct.
And you've also filed on the defendant's behalf a financial affidavit in relation to that request for a reasonable ability to pay hearing. Is that correct?
Yes.
All right. Then I will hear anything further from the defendant on the issue of reasonable ability to pay Category 2 restitution.
Your Honor, the defendant being sentenced to life in prison will not have the opportunity to have any income other than any possible work that occurs while he's in prison, which could be in the amount of 25 cents an hour or 50 cents an hour, if he's even allowed to work. So he has no income. Any money that is sent to him while he's in prison, the prison will take 20% of that money and give that to the victim's estate. Because there's the 150 to the victim, I don't believe it'll be possible, and it would not be reasonable that the defendant could ever repay. I haven't listed yet what my attorney fees are, but they're substantial. There was also substantial expert fees paid by our office, as well as the costs of the trial that will be assessed for him. And I believe that it just isn't reasonable for him to be able to pay any Category B restitution, even though we don't have the full amount today.
Thank you, Ms. Solberg. Anything on this issue on behalf of the state, Mr. McConnell?
No, Your Honor.
All right, I have considered the request by the defendant to determine whether he has reasonable ability to pay any Category B restitution. I understand we don't have all of the items of Category B restitution before the court at this time. However, my interpretation of the Albright decision and its progeny is that if I find that regardless of what those amounts are, the defendant does not have the reasonable ability to pay them, then I may go ahead at this time and make that determination, and that is the determination I make. I do find that the defendant does not have the reasonable ability to pay any Category B restitution, and I find to that effect for three different reasons. First, the defendant has been sentenced to prison for the rest of his life, and so he's going to have limited earning opportunity. Second, he's going to have to pay that $150,000 in victim restitution, which I mentioned before, regardless of my ruling on his reasonable ability to pay. So it's simply not realistic that at prison earning rates, he's ever going to be at a point where he can pay any more than that. And third, even though the court is aware that there are, like I said, some limited opportunities to earn money in prison while incarcerated, with the defendant's mental health history and his work history as reflected in the evidence received at trial, I just don't think it's likely he's going to be able to earn as much, perhaps, as somebody else in his position might be able to do. So for all those reasons, I find that the defendant has no reasonable ability to pay any Category B restitution. So as I believe I'm required to do, all of those Category B restitution items will be taxed in the sense that they're taxed at the court file, but based on my finding of no reasonable ability to pay, the defendant will not be required to pay any of that. Mr. Stowe, you do have the right to appeal your conviction and sentence in this case, and if you wish to appeal your conviction and sentence, you have to file a document called a notice of appeal with the clerk of court in this building within 30 days of today's date. If you do not file that kind of document within that time period I just described, you waive, which means give up your right to appeal. If you can't afford the cost of prosecuting an appeal, or the cost of a lawyer for that appeal, or the cost of preparing a transcript for that appeal, those will be provided to you. Do you understand that, sir?
Yeah.
Very well. There is no eligibility for an appeal bond in this case, so there won't be one set. And I will prepare a written judgment and sentencing order as soon as we are done. Anything else we need to take up at this time before we close the record, Ms. McConnell?
No, Your Honor.
Ms. Silver?
No, Your Honor.
Very well. Then that will conclude today's hearing. Like I said, I will have that written ruling on file as soon as I am able to do so. With that, we are adjourned. Everyone is excused, and we are off the record. Thank you very much.
Because he doesn't have any.
Thanks.
I'll let you go first.
Well, you have a man.
Thanks, you too. Yeah, I probably won't see you before.
Oh, no. Uh-uh.
Heck no.
Heck no.
Heck no. Oh. Oh, that's not so good.
Well, I didn't exactly know the charge, so. Okay.
I don't know if I told you, but it was the funniest thing when we watched the first football game on the live stream.
Oh, yeah.
And we, like one of our funniest things. Doesn't have to say. And did you hear what they started?
Really?
Oh, my phone with himself. I think they said a mighty fine looking software.
Oh.
So Ray goes, they could never say that. Like that is. And I go, they don't even know. You get your hands. And I go, so you don't need
Yeah, I got
hands.
my.
They need a good, you know, fit. That's what. I mean, it's just so.
Bye.
Is that right?
Yeah, that's great.
Yeah.
There you go.
I got it. No, we actually, we were at the game, so we didn't get to hear.
Well, you can't, you don't hear.
Right, so we don't get to hear the same. Well, but sometimes our parents would be watching and then they would tell us, you know, say something. Yeah,
Yeah, then it was all good. But we always say always, because it's just funny, their phraseology. You you know, or they're trying to find something to say about nothing. Yeah. Highly entertaining, but.
It is, we watched did you watch the basketball game?
No, how'd that go?
Well, they won. But
Who'd they play?
Paul, Western, they're good.
Yeah, they are.
And so I don't know who announces,
Yeah.
it's a man and a woman. We laugh because she every time says, the shot's off the mark, that's all she says every time. It's famous. So the shot was off the mark. And at first, you
Yeah, that is funny, isn't it?
the whole entire game, that's what she would say.
Oh, and think about when you shot for minutes.
Mhm.
Off the mark. Oh,
That's all. You know, you gotta come up with.
you gotta have more, that's why.
Little variety. Yeah. But,
That's why it is. And it's so many things you could say.
right.
Bounce off the rim. I mean,
Yes.
yeah.
Uh-huh.
We could help her, Amy. It was just,
Yeah, there you go.
we could send you some ideas of things to say. Gosh, the mark.
But I'm just thankful that they do that. 'Cause
Oh,
like,
so am I.
our
Thankful.
grandparents.
Well, like Rachel's play, you know, I just told her, look,
Oh, sure.
I want you to be in the play, but I'm not gonna go sit in a room with a bunch of people breathing. That's just not gonna happen.
Well,
So
yeah.
I said, but I want you to be in, and I don't want you to be whipped up on if I see it or not, because I've read your whole script, I memorized your lines with you.
We've worked on it, yeah.
Yeah, I mean, and they might live stream
Oh, I
the
bet
play.
they will. I bet they will.
They're trying to, but it's about getting the rights of the script on it. They'll allow it to be. It isn't about, yeah, the school would
Okay.
happily do it,
Okay.
but it would be great.
You would think that.
Yeah, well, people would pay. I think they'd get more money
Oh,
because
yeah.
relatives all over the country would pay to go versus just who could, you know.
Yeah.
So it'll be interesting to see if they do that. And that play, the kids hate it because it's about the life of Abraham Lincoln, and to them it's boring. She usually picks these super funny plays, and it was supposed to be last spring where they had a funny one in the fall, and then this.
Okay.
So it's,
So what part does she have?
she has like 2 or 3 parts. She's a maid. She's, you know, a couple of things. So it's just funny.
Mhm.
But like one of her lines is something like, and the North rises up against an indignation of the menace of the South. So there's these lines from like speeches he gave.
Uh-huh.
It's interesting
It is, yeah. To us.
to us,
Right.
but to learn those lines are hard because they're not like conversation
Right.
lines. They're political speeches made in 1863. So it's interesting.
Yeah. That's
Funny. Yeah.
Well, hopefully they get something figured out that you guys.
I hope so. Whatever, it is what it is. I just am glad she's in the activity,
Uh-huh.
you know.
Yeah. Yeah. Where will that be at the school?
Yeah.
Then? Like in the auditorium, or will
Yeah.
they do it out? Okay.
Somehow they've kept them 6 feet apart on
Okay.
stage. So we'll see. Yeah, it'll be, that's like January 8th and 9th coming right up.
Yeah.